in doing so. So we'll talk her up a little bit. Linda's an attorney, recently passed the bar in the last year. She's been working with our office as an attorney and also as a funding coordinator. We're going to get into a lot today about what a funding coordinator is, why it's important. But Linda, if you want to, anything else you want to add to that?
Like you said, I'm just going to keep it basic. Basically started as a law clerk and moved on up to attorney, and I love what I do.
Beautiful.
And the people you work with, right?
Absolutely.
Tremendous culture around here.
Wouldn't love it otherwise.
That's good. If you'll notice today, we have all kinds of new awesome features that Pat discovered in the software that we use so that we can all be part of this Facebook Live. We've got titles, which will guide us through the conversations that we have today. We have some of our specials that are going on right now. Not so much specials, but just things that we're offering to the community as we're all kind of going through this together. Pat created all the content down there, but essentially we're offering free powers of attorney to frontline responders. We are doing 50% off for all estate planning services. So make sure to take advantage of that while we're at home. We're doing Zoom meetings, FaceTime meetings, pretty much whatever medium works for you. Traditional phone calls as well. So don't hesitate just because you don't have the technology means.
Very good. Linda, would you like me to begin your agenda there?
Yes, please.
All right. So Linda, what is funding?
Okay. So now funding is basically the process in which the grantor being the person who
look at all these he's already using real technical terms.
I'm going to simplify.
What is a grantor? That just seems really fancy.
Yes. A grantor is the person who establishes the trust.
Oh, there we go.
So basically, funding is the process where the grantor, the person who created this trust, transfers the assets that he or she owns from their name to the name of the trust.
That seems really fancy.
And there's basically two ways to do this. You can either retitle the asset or do a beneficiary change. And now it all depends on the type of asset, depending on what change you'll make. Now, I like to use a suitcase analogy to kind of explain what funding really is and give you a picture of it. So imagine after all this COVID-19 ends, you decide to take a big trip. So the first thing you would need to do is pack a suitcase of things you need to take. Now, the suitcase is like the trust because it's going to hold the items that you're going to take on your trip. And the stuff within the suitcase are your assets, let's say. That's kind of what you own, either now or you acquired during your lifetime. The same way you cannot take an empty suitcase on your trip as if it would be no use to you. You can't have an unfunded trust because there's nothing within that trust. And now what I like to say, which I'm going to keep kind of a theme through here, an unfunded trust is just a stack of expensive papers, and that's not what you want. So I feel like today's very helpful in explaining funding because you kind of will figure out what is funding and why it's truly important. You don't want to just have a stack of expensive papers.
So funding is a thing that happens with just trusts, or does it happen with wills too? What exactly is that funding when you're tying the assets to the trust?
So with a will, unlike a trust avoids probate. So you don't have to go through probate. However, a will, it typically will have just that pour-over language, which is if you forget, let's say, to add an asset that's just a safety net, you would need a trust to fully have it funded.
Okay.
So if I'm hearing you though, because I know you mentioned pour-over will, that would be if you had a trust. But so to me, I'm hearing that a will is just essentially, it's going to go through probate. And it's going to be as instructions for a judge as to how you want your stuff to be handled or distributed. Mm-hmm. And then a trust is actually a thing that holds your assets.
Correct.
And by thing, Mike, do you mean like a legal entity, like maybe similar to a corporation or a person?
Oh, man, that's good. That sounds right. Yeah, I think so. Very similar to that.
Interesting. All right. So we know that funding is this process of tying the assets to the trust. So as you said, if it's a home, maybe you deed the home to the trust, or if it's, an IRA or life insurance, you'd make the trust the beneficiary designation on those policies. So how does it work? How does it work at the Rutkowski firm? What does funding look like there?
Just like everything else at the Rutkowski Law Firm, we strive to give you that white glove experience, and I'm going to kind of explain to you what that is.
Oh, that's so good, Linda.
So I'm going to kind of give you a quick steps of what our funding process looks like with the Rutkowski Law Firm, and then you can kind of compare to how you've had it with other firms. Basically, the first step is you're given a financial questionnaire. Basically, that lists your assets, what type of assets you own, who owns it, where is it held at, what's the amount. All this information is important because then the next step would be you'll kind of review with us what happens to each asset. So we're not just going to kind of have you fill it out. We're going to guide you through every single step. Once we review each asset with you, we're going to decide what changes or what updates are we doing to that asset to tie it to the trust, which is the funding part. Now, something that kind of makes us stand out from other firms, not only do we draft asset transfer letters, which basically gives instructions to the institutions of what happens with that asset, we complete any and all forms, institution-specific forms for each company. So instead of it being multiple steps, we kind of kill a lot of steps in one. We do the forms for you, we properly complete them for you, and we also submit them to the institutions. And once the institutions receive them, they may send you other additional forms, and all you have to do is get them over to us, and we complete those for you as well. So your only step would be just to kind of get the stuff over to us. We take care of every little thing for you in the funding process. We don't just give you the paper and say, here, go figure it out. We guide you through every step.
That does sound very white glove. And I'd like to take a step back and like talk about a little bit of how we got to the process that we do now. And, you know, essentially what we found, I don't know, 8+ years ago is that so many families were coming in to have revisions done to current estate planning documents. And we would go through, you know, essentially the changes that they want to make and talking through maybe some updates. And then we get to the part of, you know, what's in your trust. And we always get this like deer in headlights. What do you mean by what's in my trust? I had this attorney do it for me. And doesn't that mean everything's in this trust? I signed this basic like personal property assignment to the trust or blanket assignment, and they thought it was funded. They didn't think there was anything else they need to do. And also we've experienced that just because the process can sometimes be complicated and just take a little bit of time, that it's just another step that just doesn't get done. So we were recognizing there were so many unfunded trusts out there that's where we kind of just we took it as a firm position, like we are funding trusts for the families we work with because of how important it is. Essentially, nothing that we do works, at least on the asset side, unless a trust is properly funded.
Exactly.
So you're telling me that funding the trust is important?
Very important.
Yeah, I say this all the time. Sometimes it's more important than the words that are on the pages, because if we don't get assets into that trust, that legal entity that you've created, none of the things that we're trying to accomplish work.
Interesting. And so, Linda, let me ask you, if you see a trust, if somebody brings in that binder that all these folks have, and you're looking just at the trust documents, is it possible to tell whether or not that trust is funded?
Great question, Pat. No, absolutely not. The way you could tell if a trust is fully funded, you basically would look at confirmations from the companies that you hold these assets with, and they'll tell you that the trust is tied to it. But just looking at the trust itself, there's no way of knowing.
Interesting. So a funded trust and an unfunded trust can look exactly the same.
Exactly.
Okay. So, but maybe if you go look at the title to your home, right, or the tax bill that you get on that, or maybe statements from banks, that sort of thing.
Yes, exactly. And those are ways to tell, and confirmations received from those companies.
Gotcha. Okay. So it's not just within the trust. You have to go out in the world to do all of this.
Exactly. And that's what we help you with. That's why you get that white glove experience.
But it's not really that big a deal, right? I mean, it doesn't have to be funded, does it?
Now we've got to why it's important.
Oh, okay.
This will kind of explain why it's important, why it has to be funded. So now there's top 3 reasons why I feel like it's very important to fund. The main reason why people even come in to do a trust is to avoid probate. which is that court process that is costly and time consuming. Not having a properly funded trust does not avoid probate. So if you want to avoid probate and actually accomplish the goal of avoiding it, you'd have to have a fully funded trust. So that's the first top reason, I'd say.
Okay.
The second reason would be your wishes within the trust are followed. So the trustee is basically a person who manages the assets within the trust. If you're not funding or connecting your assets to this trust, they can't manage it. They can only manage what's within that suitcase or within that trust, and you do that through funding.
So I have a question for you on that. So if let's say you set up a trust and you take all this time to create this well-crafted, like, here's what happens if I pass away, if one of my kids passes away, it's going to do this, it's going to do that. You know, you've spent the time to make this comprehensive plan, and then you just leave your kids as beneficiaries on your accounts. What happens then?
So then the trust, you can be very creative. What happens? Let's say one of the kid has passed away. What happens then? Let's say you want a kid to get at a certain age, which you have probably designated in your trust. The trust covers all of that. Beneficiary designations do now.
So let's say, you know, you've got, you're somebody in Mike's situation. You've got 3 very responsible young children.
That's not me.
No, that's not you. All right. Let's say you're really in Mike's situation. And you have 3 children. Now you've got a trust that says, you know what, until those kids are 30, this money is going to be held for their benefit. It'll pay for school. It'll do those things. But we won't just give, you know, some 19-year-old kid the money, right? So you have the trust that says that. But then over here, you've got your IRA, your 401k, your life insurance policy. And on that, you just name the kids as direct beneficiaries. That's fine, right? Because it avoids probate and, you know, you set in your trust so they won't get it till 30, right?
No.
No.
So with that beneficiary designation, once the kid is of legal age, let's say they're 18, above the age of 18, they're 19-year-olds, and they're the beneficiaries, they're going to get it in their hand. However, if the trust is made as the beneficiary, it goes through the trust, and instead of them getting it at the legal age, they get it at the age you have decided within the trust. So no, it is not the same thing.
Oh, interesting.
Yes.
Sure. Thing. Sounds like this funding is pretty important.
Oh yeah, definitely up there.
All right.
I want to take that one step further also, because we get this question quite often when it comes to like IRAs. Can you make the trust the beneficiary of an IRA, and why wouldn't you maybe do that? Because we get so many financial advisors or wealth managers that give us a little pushback on doing so. And I'd just love to hear your thoughts on it, and maybe Pat can talk about it too.
Okay, so I'm going to start off and then Pat can kind of add on to this. But basically, if we have a husband and wife situation, we typically keep the spouse as primary, so they can basically roll it over into their existing IRA, and we make the contingent or the backup beneficiary to being the trust. That way you don't lose any benefits. And if the spouse was to pass away, then it falls into the trust, and the trust will kind of designate how the funds are distributed.
Yeah, and what Mike was saying, the pushback we get often from financial advisors on that, what they're worried about is this IRA or this 401k being taxed at a trust rate of tax, or that the money all gets dumped into this trust and it has all these horrific tax consequences. And they say, well, it's easy enough. You just name the beneficiaries and there you go. It is easy to name beneficiaries, and sometimes quick and easy things aren't necessarily the best things. So number one, you don't just want to go around and name any old trust as the beneficiary of an IRA or a 401k. You have to make sure that that trust is one that can receive those funds, that won't have any sort of negative tax implications. And then on the flip side, why wouldn't you name the kid as the direct beneficiary? Well, maybe they're underage, or maybe they could get divorced, or maybe they could have medical issues or bankruptcy issues, things like that. Well, if that were to happen and you name them as the beneficiary on that IRA, the money just goes straight to them, regardless of what's going on in their lives. But if we filter it through the trust, then we can adapt to those different situations. Maybe they are sick. Maybe they're not in the best financial space. I mean, there's a lot of folks out there right now who maybe it wouldn't be the best thing in the world if they got a whole bunch of pre-tax dollars this year, like right now. Might not be a great thing, or maybe it would. It just depends. So that flexibility, I think, is a big component as well. So,
Great.
Linda, did you say you had a third reason for importance?
Yes, I do. And the third reason is assets basically outside of the trust might not go to your intended beneficiaries. Now, what I've seen through all the years I've done funding, that people don't even realize the beneficiary designations they have on the accounts. Mm-hmm. Sometimes you'll see ex-spouses that are still left on there, and they don't realize it until they kind of go through this funding process and realize, oh, that is not who I intended to be the beneficiary. So that kind of, the trust will kind of capture all that. It will give you a way to kind of take a step back and look at where are all my assets, who is getting them, and all the kind of covers all the buts and the what ifs through the trust.
And that's something really important on there. You mentioned the ex-spouse. What a lot of people don't realize, there was a U.S. Supreme Court case, the Kennedy decision, that held that those beneficiary designations overrule everything, including your intent. In the Kennedy case, a man got divorced, totally redid his trust, redid his will, redid everything, but never took his wife off of, his ex-wife, off of his IRA. Then he passed away 5 or 6 years later, and sure enough, the ex-wife got every dime of that retirement account. Even though it was very clear, no one was arguing that he wanted her to have it. It was just, hey, that's what the beneficiary designation says, so that is what's going to happen. And you can get frustrated about that. The kids were quite frustrated about that, because it was very, very clear Dad didn't want that to happen. But if that's what you have named, that's what's going to happen. Just another reason why it is so, so important to know how your things are set up, both from the financial and the legal point of view, and the way that those tie together.
Yeah, a couple of interesting things that we found as going through the funding process with families is, you know, with financial institutions kind of selling off different things, or maybe changing names, like I know JP Morgan, Chase, that whole like conversion. We've actually seen where beneficiary designations have fallen off, where they just didn't get transferred in the system as they were going from one system to another. So this is really a good opportunity also, just to make sure that everything's buttoned up. Another point I also want to make is that a lot of the stuff that we're talking about when we're talking about processes and what we do and how we do it, I mean, a lot of it applies to, you know, 75% of everything that we do, but everything's always evaluated on a case-by-case basis. You know, maybe we're not making the spouse the primary beneficiary of an IRA, and then the trust the contingent beneficiary. We need to look at what are the goals we're trying to accomplish, and then evaluate, you know, what is the best way to fund that trust, because there's certain situations that would require a different funding strategy.
Indeed. So, Linda, what can be put into a trust?
Okay, great question. So I'm going to kind of list off some of the things that can be real property, like your home, your land, other real estate that you own, cash accounts like your bank accounts, credit union accounts, your safe deposit boxes, your investment accounts like your CDs, stocks, mutual funds, or even business interests that you own that you kind of want after you have passed away to fall into this trust. And also personal property. Although this is more of the estate planning paperwork that comes in, we have a personal property memorandum, which comes with typically all of the estate planning documents we hand out, which lists basically any artwork, clothing, jewelry, sporting equipment, stuff that you want to give to certain individuals. You list it out on this sheet, and it kind of tells you who gets that item. And
so do I have to list out every single item in my house?
No, it's only if you want, let's say you have an antique clock you want this specific son to have, and that son must have it, then you would. Otherwise, everything falls into the trust and gets distributed accordingly.
Okay, I got you.
Yes. And some other things, which is basically through a beneficiary designation typically, which are retirement accounts, health saving accounts, life insurance policies. Those are typically ones we do through beneficiary, because you cannot retitle those.
Okay. So a trust, or at least your trust when you set it up, like a living trust set up while you're alive, can't own an IRA, but it can be the beneficiary of an IRA?
Correct.
Gotcha. Okay. And that is one I would just say, for anyone out there listening, before you name a trust, if you have a trust, before you name the trust as the beneficiary of an IRA or 401k, have an estate planning, have an elder law attorney review the trust, because with some trusts, there are really bad tax consequences to making them the beneficiary of that IRA. For others, like ours, where we're planning for it, it's just fine. But if you take, an awful lot of the trusts that are out there, you could find yourself in a precarious tax situation. So if there are things that can be put into trust, are there also things that can't or shouldn't be put into trust?
Okay, so we typically do not recommend that you retitle a car into the name of the trust, and I'll give 2 reasons why. The first reason being, if you were in a car accident and the other party decides to come and sue you, if they see that your car is owned by a trust, they think you have deep pockets, meaning they think you have a lot of money, which is truly not the case always, but that's just kind of a misconception that people think when they see that. And a second reason would be a car can easily be transferred into whoever's name you want by simply bringing a copy of the death certificate to the Secretary of State office and filing some forms. So it's not something that you would need to do right now. It could be done post-death.
Understood. Is there anything else that falls into that category? I also for not putting a vehicle in. I know some of the folks we work with, they set up trusts to kind of protect themselves from liabilities. And if the car is in the trust and then the car gets in an accident, effectively now the trust has gotten into a car accident as well.
That's a good point. Yes.
Maybe don't want to open yourself up to quite all that, but
for sure.
But for an awful lot of folks too, who have either a classic vehicle collection, or maybe they've got a couple, they've got a few high-end cars or something like that. I mean, it's Michigan. People do love their cars around here. So sometimes when we get into those situations, you might treat it a little bit differently as well. Like Mike was saying earlier, it's not a one-size-fits-all kind of fill in the blank or boilerplate type way of doing it.
I think that is a perfect example of that, because it all depends on like who you want to get your car. Because if you wanted, let's say, a good friend of yours to have your car after you pass, well, they can't go to the Secretary of State with a death certificate and have it retitled. There's specific rules about who can do that. Typically, it's an heir of yours. It's not going to be your friend. So then we just have to really weigh the pros and cons of putting that automobile in the trust, and is that something we want to do? And we'll just have that conversation kind of together. It always has kind of blown my mind how difficult the probate process can be in Michigan, but yet transferring an automobile to a child is as easy as it is. I'm always just guessing that maybe because the big 3 is here and it has something to do with it. I don't know. I mean, that was my best guess to it, because I know other states are not quite as easy when it comes to transferring cars and automobiles. Definitely not.
So, I mean, this is clearly something that is really, really important to get done. If you have a trust and you don't fund it, then it's not going to work. And it's kind of shocking, I've found, when you go out there and you talk to financial advisors or you talk to anyone who deals with trusts on a regular basis, 95, 99% of trusts that they see are unfunded or underfunded, that won't actually do any of the things that are why the person set them up. So why is that? I mean, won't my attorney fund my trust for me? Like, if I set it up, aren't they gonna make sure that happens?
Well, it depends. Is your attorney from the Rutkowski law firm?
Should be. They should be.
Should be. But most attorneys will basically handle the real estate, do a deed, and give you instructions, if any, of how to fund your trust, and kind of you're on your own. And of course, when people are given that, they think, oh, I have a trust. Why do I need to take additional steps? They think that's the final step, which it's not. They think that's it. It's done. It's fully funded. Everything's ready to go. And they don't know until they've passed. And it's like, wait, nothing's in the trust. So it's going to be a little too late then. And that's kind of the difference with working with our firm. We handle the funding for you. We basically will explain the process to you, guide you through all the forms, fill them out for you, and make sure you kind of get that little ribbon on top and, make sure everything's just fully funded. And it's not just a trust, it's a fully funded trust. And that's the difference between our firm and I'd say other firms.
So that's an extra cost, of course, right? On top of things. I mean, that's not just part of the way that we do it, is it?
So there is an extra cost for funding, but it's well worth it. It's like, why would you pay for a trust and not have it funded? It won't work the way it should.
Gotcha. I was going to say more, when we're doing any trust that we're setting up, we are going to make sure that that's funded. But we've also run into it too, where people have brought trusts from other firms where maybe they're okay keeping what they have, but that next step has to happen and it has to get funded. There have been a number of people I know whose trusts I've reviewed, Mike, you as well, where they set it up, but there's nothing in it. And so we just have to either fund that trust or redo it right in the first place.
Yeah.
And that's not...
Just to clarify on what Linda said, it's typically part of our process if we're doing, and it becomes even more so valuable when we're doing asset protection planning, which we've talked about a little bit on some of these Facebook Lives before. But like Pat said, if someone comes in to have their trust reviewed, we go over it and everything looks good, but maybe it's just not funded, we can definitely help out with just that part of it if that's something that needs to be done.
And to address a question just here from Angela, could I have your firm fund any accounts or property that I acquire after the initial funding of my trust? So short answer is yes. Certainly can have us fund new assets into a trust that you got after you set it up. But that also touches on kind of another thing that we come across. Let's say that you set up a trust and you fund it properly. You put your bank account in there, you make it the beneficiary of your 401k, you put your home in there, everything is properly tied and titled. But then you move and you convert your 401k to an IRA and you change from the bank to the credit union. Well, each one of those steps is a time where something can fall out of the trust. Your old house was in there, but then the new house isn't. Your 401k had the right beneficiary, but then when you did the conversion, you didn't confirm that the new beneficiaries were set up right. And so now that's not on there. And when you open the new bank account or the new credit union account, you did that as a private person, as opposed to as the trustee of your trust. So it's kind of an ongoing thing to make sure that that's buttoned up. I would say.
Hey, Linda, another question for you, totally different subject, but I feel like it's something we're dealing with a lot right now because of how interest rates are so low. We get a lot of people that are reaching out right now about their refinancing their mortgage. They're getting pushback from the lending institution because their property is in trust. Is that part of something that you would handle if the lending institution requires it to be taken out of trust to refinance and then put it back in trust? Is that simple enough? What are all the steps involved in something like that?
Yes, it's actually pretty simple. It's just a matter of drafting 2 deeds. One, it would be to take it out of trust, get the refinancing to go through. Once we get the green light that the refinancing has went through, then we're going to have a second deed, which you sign both deeds at the same time. We're going to file that second deed, putting it back into trust. So it's just a matter of doing 2 more deeds. Yeah. One, taking it out until refinancing goes through. Once we get green light, put it back with the second deed. It's an easy.
So how are you doing that right now if the courts are closed?
E-filing, all deeds.
What does e-filing mean?
Filing online through Simplify. We don't have to go to court to do all that.
if I want to meet with you, you'll meet with me like this, like through, I mean, this is Facebook Live, but like we could have like a Zoom meeting, right? And I could explain to you what I need to have done. I could maybe either take a picture with my phone of my deed or whatever the case may be, and we could do things virtually still.
Absolutely. We can even e-notarize for you that deed and take care of filing it.
And so you're not in the office right now.
No, I'm actually home, sitting in my room right now.
That is cool. Well, okay, then people should take advantage of that.
I agree.
Take advantage of the low interest rates and go refinance your loan with an institution like Quicken Loans, and then come talk to Linda.
I'll be ready.
Shout out to Quicken.
Very good. All right. I am not seeing any more ongoing questions. If anyone does have anything for any of the three of us or our fantastic guest, Linda, today, please don't hesitate to ask. And you can always call us at 1-800-ESTATES or locally 248-792-9193, or just reach out to us at rutkowskilawfirm.com, here for all your elder planning and asset protection needs. Not seeing anyone typing, and we've been going for about half an hour. So
before we wrap, touch on the things that we want people to share. If you know anyone that's out there, frontline responders, we can work with them on their schedule. I know they're crazy busy, but we're just doing nothing but sitting at home. So if they need to meet at night or whatever on a Zoom call so we can get those powers of attorney in place, we can be flexible on that. Also share with whoever that if they need estate planning services while this is all happening, we're doing the 50% off deal. So please share this with whoever. We appreciate it.
All right. Fantastic. Linda, great seeing you.
Likewise.
All right.
See you guys.
Take care. Stay safe out there.
Yep.